In 1971, a 26-year-old schoolteacher in Ohio told her principal she was expecting her first child. She had been teaching for 3 years with perfect reviews. He told her to pack up her desk by Friday. She was not being punished. She was being forced out because pregnant teachers were required to leave the classroom. However, what happened to her and to millions of women like her reveals just how recently the American workplace treated pregnancy like a fireable offense. 15 years before that teacher was sent home, the American workplace looked like a completely different world for women. In the 1950s, women who worked outside the home were concentrated in a narrow band of jobs. They were secretaries, telephone operators, nurses, and teachers. The assumption built into every office policy and every corporate handbook was simple. A woman worked until she got married or until she got pregnant, and then she went home. That was the deal. Nobody questioned it publicly because the entire economic structure of the country was built around the idea that the male breadwinner supported the family and the woman managed the household. Employers did not see this as discrimination. They saw it as the natural order of things. And because they saw it that way, they wrote rules that enforced it at every level, from the hiring office to the insurance plan to the employee handbook sitting in the break room filing cabinet. If you were a woman walking into a new job in 1955, the unspoken clock was already ticking. The only question was whether marriage or pregnancy would end your career first. This was not some quiet, unspoken understanding either. Companies put it in writing. They printed it in their policy manuals. And some of the most blatant examples came from the airline industry, where the rules imposed on female flight attendants were almost unbelievable by today's standards. Starting in the late 1950s, major airlines, including Pan Am, United, and TWA, required their stewardesses to be unmarried. If a stewardess got married, she was terminated. If she became pregnant, she was terminated. If she turned 32 or 35, depending on the airline, she was terminated. The airlines did not even pretend these rules were about job performance or passenger safety. They openly admitted they wanted young, attractive, single women serving passengers because it was good for the brand. A 1967 advertisement from Braniff Airlines featured stewardesses in designer outfits, and the marketing copy asked passengers if they had noticed the body on their 747. That was the environment women were working in. They were decorative. They were temporary. And the moment they showed any sign of building a life outside of the airplane cabin, they were shown the exit. Some stewardesses tried to hide their pregnancies for as long as they could, wearing girdles and loose-fitting uniforms to buy themselves a few extra weeks of income before the inevitable termination. Others were caught during the mandatory weigh-ins that airlines conducted before shifts. Gain a few pounds in your first trimester, and a supervisor might start asking questions you could not afford to answer honestly. The women who were fired received no severance, no benefits continuation, and no right to return after having their child. Years of experience, training, and seniority vanished overnight. And because these policies were standard across the entire industry, there was nowhere else to go. Every major airline played by the same rules. If you wanted to fly, you accepted the terms. And the terms said your body belonged to the company. But airlines were far from the only industry pulling this. School districts across the country had mandatory maternity leave policies that forced pregnant teachers out of the classroom as early as the 4th or 5th month of pregnancy, regardless of whether the teacher was healthy enough to keep working. The reasoning school boards gave was almost comically patronizing. They argued that the sight of a visibly pregnant teacher would be disruptive to students. Some board members actually said it was inappropriate for children to see evidence that their teacher had been sexually active. This was the 1960s and early 70s, not the 1800s. And these policies were not gentle suggestions or informal guidelines. They were absolute requirements backed by the threat of termination. A pregnant teacher who refused to leave could be fired for insubordination on the spot. There was no appeals process, no room for a doctor's opinion, and no negotiation. The policy said leave, so you left. The consequences went far beyond losing a few months of income. When these teachers were forced out, They lost their seniority. They lost their benefits. Many lost their health insurance at the exact moment they needed it most, right when they were about to give birth. And the policies typically required them to stay home until the semester after their child turned 3 months old, sometimes longer. There was no guarantee their position would still exist when they came back. Some women returned to find their classrooms had been given to permanent replacements. Others were offered positions at different schools, farther from home, with worse schedules. For women who were the primary earners in their families, or who were raising children alone, the financial hit was devastating. Months of lost wages during pregnancy, no income during recovery, and the very real possibility that the career they had spent years building simply would not be there when they tried to pick it back up. And it was not just teachers and stewardesses dealing with this. Women working in factories, offices, and retail stores faced their own version of the same problem. In manufacturing plants across the Midwest and the South, pregnant assembly line workers were given a choice that was not really a choice at all. Keep working at the same pace with the same physical demands, or go home. There were no accommodations for pregnant workers, no lighter duties, no temporary reassignments. If the job required standing for 8 hours or lifting heavy parts, you either did it or you quit. And if you quit, you lost your seniority, your pension contributions, and your spot on the line. Some women worked right up until they went into labor because they literally could not afford to stop. Others were quietly let go by supervisors who decided a pregnant woman was a liability on the factory floor. Either way, the message was the same. Your pregnancy was your problem, not the company's. In office settings, the discrimination was less physically dangerous, but just as damaging to women's careers. A secretary who announced her pregnancy might suddenly find herself excluded from important meetings. A junior executive who was visibly expecting might watch a promotion go to a less qualified colleague, with no explanation offered beyond vague comments about the timing not being right. Women quickly learned to do the math. If you wanted to advance, you timed your pregnancy carefully, hid it as long as possible, and prayed your employer did not hold it against you when the news finally came out. The professional cost of motherhood was a tax that men simply never had to pay, and it compounded over the course of an entire career in ways that were difficult to quantify but impossible to ignore. This is where the story takes a turn nobody expected. Because while these rules were humiliating and economically crushing for individual women, the legal system offered almost no protection. Title VII of the Civil Rights Act of 1964 made it illegal to discriminate on the basis of sex in employment. You would think that firing someone for getting pregnant would fall squarely under sex discrimination, since only women can get pregnant. But employers and courts spent the next decade and a half arguing that pregnancy discrimination was not sex discrimination at all. Their logic went like this: not all women get pregnant. Therefore, distinguishing between pregnant employees and non-pregnant employees is not the same as distinguishing between men and women. It sounds absurd now, but that legal argument held up in courtrooms across America for years because nobody with enough legal firepower had managed to tear it apart yet. The first real crack in the wall came out of Cleveland, Ohio, in the early 1970s. Jo Carol LaFleur was a junior high school teacher who was forced to take unpaid maternity leave 5 months before her due date under the Cleveland Board of Education's mandatory leave policy. LaFleur did not want to stop teaching. She felt healthy. Her doctor confirmed she was perfectly fit to work. But the school board did not care what any doctor had to say about it. LaFleur hired an attorney and filed suit. Her case, Cleveland Board of Education versus LaFleur, worked its way through the federal courts and all the way up to the United States Supreme Court. In January of 1974, the court ruled in LaFleur's favor, striking down mandatory maternity leave policies on the grounds that arbitrary cutoff dates for pregnant workers violated the Due Process Clause of the 14th Amendment. The justices said that these policies created an irrebuttable presumption of incapacity, meaning they assumed a pregnant woman could not do her job without any evidence to support that assumption. In plain English, you could not just declare a pregnant teacher unfit to work because a calendar said so. You had to actually look at her individual situation and her actual ability to do her job. Women across the country celebrated the LaFleur decision, and they had every reason to. But here is the detail that everyone missed at the time. The ruling was narrow. It struck down mandatory leave policies, but it did not address the larger question of whether pregnancy discrimination counted as sex discrimination under Title VII. That question was still wide open. And just 2 years later, the Supreme Court answered it in a way that shocked nearly everyone who had been following the issue. In 1976, the court heard General Electric Company versus Gilbert. The case involved General Electric's Employee Disability Benefits Plan. The plan covered virtually every medical condition a worker might face: broken bones, surgery, chronic illness, recovery from accidents, all of it. The one condition the plan specifically excluded was pregnancy. A group of female GE employees sued, arguing that excluding pregnancy from a disability plan that covered everything else was a clear case of sex discrimination under federal law. The argument seemed almost impossible to lose, but the Supreme Court disagreed. In a 6-3 decision, the court ruled that pregnancy discrimination was not sex discrimination. Justice William Rehnquist wrote the majority opinion, and his reasoning went like this. The disability plan did not divide employees into categories of men and women. It divided them into two groups: pregnant persons and non-pregnant persons. Since the group of non-pregnant persons included both men and women, there was no sex-based classification, and therefore no violation of Title VII. Justice William Brennan wrote a dissent that practically burned through the page. He called the majority's reasoning a willful blindness to biological reality. He argued that pregnancy is a condition unique to women, and that penalizing it in the workplace was inherently discriminatory no matter how you carved up the legal categories. But dissents do not change the law. The Gilbert decision stood, and it meant that employers across the country now had Supreme Court approval to treat pregnancy as something separate and distinct from sex discrimination. Companies could exclude pregnancy from insurance plans. They could deny pregnant workers the same accommodations they routinely gave to injured or sick employees. And they could do all of it without breaking a single federal law. The reaction to the Gilbert decision was immediate and explosive. Women's rights organizations, labor unions, civil rights groups, and newspaper editorial boards across the country condemned the ruling in the strongest terms available. The National Organization for Women called it a betrayal of working women everywhere. The American Civil Liberties Union issued a statement warning that the decision essentially gave employers a green light to punish women for biology. Letters and phone calls flooded into congressional offices by the tens of thousands. Advocacy organizations mobilized their members in ways that had not been seen since the fight for the Equal Rights Amendment. Rallies were organized outside courthouses and federal buildings in major cities across the country. And something remarkable happened as a result of that sustained, organized, unrelenting pressure. Congress moved faster than almost anyone predicted. Within 2 years of the Gilbert ruling, lawmakers passed the Pregnancy Discrimination Act of 1978. The law amended Title VII to explicitly state that discrimination on the basis of pregnancy, childbirth, or related medical conditions constitutes sex discrimination. The law required employers to treat pregnant employees the same as any other employee with a temporary disability or medical condition. If your company gave light-duty assignments to workers recovering from back surgery, you had to offer the same option to pregnant workers. If your health insurance covered appendectomies and broken legs, it had to cover pregnancy-related medical care too. The Pregnancy Discrimination Act was a direct congressional override of the Supreme Court, and it sent a clear signal that the American workplace could no longer pretend pregnancy existed in some special legal category outside the reach of anti-discrimination law. The debate on the floor of Congress was revealing in its own right. Supporters of the Pregnancy Discrimination Act argued that pregnancy was a normal part of life, that women made up a growing share of the American workforce, and that forcing them to choose between having children and having careers was economically irrational and morally wrong. Opponents pushed back with predictions of runaway costs, arguing that small businesses would collapse under the weight of paying for pregnancy-related benefits and holding jobs open for women on maternity leave. But the momentum was overwhelmingly on the side of change. The bill passed with bipartisan support, and President Jimmy Carter signed it into law in October of 1978. For millions of working women, it felt like the beginning of a new era. But passing a law and enforcing a law are two very different things. And this is the part of the story that does not get told often enough. After 1978, the overt firing for pregnancy policies disappeared from employee handbooks almost immediately. Companies stopped putting the quiet part in writing, but the discrimination itself did not vanish. It just changed form and went underground. Throughout the 1980s and 90s, women across the country reported being passed over for promotions after announcing pregnancies. They were quietly reassigned to less desirable positions. They were pressured to take extended unpaid leave and then informed that their roles had been restructured or eliminated while they were away. Some women were asked during job interviews whether they planned to have children in the near future. A question that was technically illegal but nearly impossible to prove had been the reason they were not hired. The tactics were subtler than the old written policies, but the results looked almost identical to what had come before. The problem hit hardest in physically demanding jobs. In factories, warehouses, retail stockrooms, and delivery companies, pregnant workers who needed basic accommodations were routinely denied them. A woman who needed to carry a water bottle on a warehouse floor to stay hydrated was turned away because company policy prohibited personal items in the work area. A pregnant retail employee who needed to sit on a stool during a 12-hour shift was told to go on unpaid leave because the job description technically required standing. Employers argued that the Pregnancy Discrimination Act required them to treat pregnant workers the same as everyone else, but not to treat them any better than anyone else. So, if the company had no existing light-duty policy for anybody, a pregnant worker who could not safely lift heavy boxes had exactly two options: risk her health or go home without a paycheck. This interpretation of the law created a brutal gap where employers technically obeyed the statute while completely undermining what it was supposed to accomplish. One case that captured this problem in vivid detail involved a woman named Peggy Young. She worked as a package delivery driver for United Parcel Service in Landover, Maryland. Young had been with UPS for years. She knew the routes, she knew the job. When she became pregnant in 2006, her doctor gave her a 20-pound lifting restriction. Young asked UPS for a temporary light-duty assignment, the exact kind of accommodation UPS regularly offered to drivers who had been injured on the job, who were recovering from surgery, or who had lost their commercial driver's licenses for reasons having nothing to do with their physical ability to deliver packages. But UPS refused her request. They told her that pregnancy was not a qualifying condition for the light-duty program. It did not matter that the physical limitation was the same. It did not matter that she could still do every part of the job, except the heaviest lifts. Pregnancy was pregnancy, and their policy did not cover it. Young was forced onto unpaid leave, lost her medical insurance during the pregnancy, and nearly lost her home because she could not keep up with the mortgage payments while earning nothing. She decided to sue. Her case spent nearly a decade grinding through the courts before finally reaching the United States Supreme Court in 2015. The court's ruling in Young versus United Parcel Service was a partial win. The justices determined that Young had a valid discrimination claim and that employers could not refuse to accommodate pregnant workers while freely giving the same accommodations to non-pregnant workers with similar physical limitations. But the decision also left a lot of gray area. It established a complicated legal test that placed the burden on the pregnant worker to demonstrate that her employer's stated reasons for denying the accommodation were not strong enough to justify the burden it placed on her. In practical terms, this meant that pregnant workers still had to hire lawyers, gather evidence, and fight through months or years of costly litigation just to secure the kind of accommodation that an employee recovering from a weekend sports injury might receive without question. The playing field was more level than before, but it was still tilted, and the broader numbers throughout this era told the same frustrating story. Pregnancy discrimination charges filed with the Equal Employment Opportunity Commission numbered in the thousands every single year from the late 1990s through the 2020s. Women in low-wage jobs, women of color, and women in physically demanding positions bore the heaviest burden. A pregnant retail worker who needed a stool to sit on might lose her job over it. A warehouse employee might face the impossible choice between her own physical safety and her family's next paycheck. These were not policy abstractions debated in conference rooms. These were real women making real calculations about whether they could afford to be both pregnant and employed at the same time. The push for stronger protections continued for years after that. Advocacy groups like A Better Balance and the National Women's Law Center argued that the Pregnancy Discrimination Act, while meaningful for its time, did not go far enough for the modern workforce. It guaranteed equal treatment, which mattered, but it did not guarantee reasonable accommodation, which mattered more. In a country where millions of jobs require standing, lifting, and physical labor, that distinction was enormous in practice. If your employer had no existing light-duty program for anyone at all, a pregnant worker had no legal right to request one, even if continuing to work without accommodation put her health or her pregnancy at genuine medical risk. That gap finally started to close in 2023 when Congress passed the Pregnant Workers Fairness Act. This law, which took effect in June of that year, required employers with 15 or more workers to provide reasonable accommodations for known physical limitations related to pregnancy, childbirth, or related medical conditions. The kinds of accommodations covered included things like additional bathroom breaks, temporary reassignment to lighter tasks, modified work schedules, or simply being allowed to sit instead of stand during a shift. For the first time in American history, pregnant workers had an explicit federal right not just to be treated the same as everyone else, but to receive the specific adjustments they needed to keep working safely through their pregnancies. But consider what that timeline actually means. The Pregnancy Discrimination Act became law in 1978. The Pregnant Workers Fairness Act became law in 2023. That is 45 years between the law that said you cannot fire a woman for being pregnant and the law that said you actually have to make reasonable changes so she can keep doing her job during pregnancy. 45 years. An entire generation of working women built their careers inside that gap, knowing their employers could follow the letter of the law while still making it nearly impossible to work through a pregnancy without sacrificing their health or their financial stability. And even now, enforcement remains unfinished business. Pregnancy discrimination complaints still number in the thousands annually across the country. Women in states with weaker labor protections continue to face retaliation for requesting even minor workplace adjustments. Some employers have found new ways to penalize pregnant workers without technically violating the law. Attendance point systems that do not distinguish between a sick day for a cold and a sick day for severe morning sickness. Performance reviews that suddenly dip after a pregnancy announcement. Scheduling changes that make it impossible for a pregnant worker to keep her hours without asking for the very accommodation she knows will put a target on her back. The patterns are hard to prove in court, which is exactly why they persist. Cultural attitudes have shifted enormously from the 1960s, and that is worth acknowledging. Open hostility toward pregnant workers is far less socially acceptable than it once was. But studies continue to find that hiring managers are measurably less likely to call back job applicants who are visibly pregnant, even when their resumes and qualifications are identical to other candidates. Researchers at Rice University conducted experiments where they sent identical resumes to employers, varying only whether the applicant appeared pregnant in the interview setting. The results showed a clear and consistent bias against pregnant candidates. The discrimination migrated from written company policy to unconscious individual behavior. And unconscious behavior is something you cannot simply legislate away with a single federal statute. What makes this entire history so striking is not only the individual stories of women who lost their paychecks, their insurance, their seniority, and their careers. It is the fact that every single workplace protection pregnant women have today was fought for, litigated, lost at least once, appealed, and eventually won through decades of relentless effort by women who refused to accept the way things were. Jo Carol LaFleur could have packed up her classroom and gone home quietly. Peggy Young could have accepted the unpaid leave without a fight and moved on with her life. They did not. They put their names on lawsuits, endured years of legal uncertainty, and risked professional retaliation with no guarantee of the outcome. And the laws that eventually passed were not gifts from lawmakers who spontaneously discovered a sense of fairness. They were concessions extracted by organized women and their allies who testified before committees, lobbied in hallways, marched in the streets, and made the political cost of doing nothing higher than the cost of doing something. This is not the distant past either, and that is the part of this story that stays with you. A woman who was fired for being pregnant in 1975 would be in her mid-70s today. She is not a historical figure from some far-off era preserved in a dusty textbook on a library shelf. She could be your mother, she could be your grandmother, she could be the woman who lives down the street and never talks about the career she lost before you were born. The teachers who were sent home from their classrooms for showing a visible pregnancy might still be around to tell you exactly how it felt to be escorted out of a building where they had spent years educating children. The flight attendants who were weighed before shifts and terminated for gaining a few pounds during their first trimester might be sitting across the table from you at a holiday dinner. This is living memory. And the women who went through it carried the financial and emotional consequences for the rest of their lives. Lost wages that were never recovered, gaps in their resumes that cost them future opportunities, promotions they never received, retirement savings that never caught up, and the persistent, quiet knowledge that their employers valued their labor only so long as their bodies cooperated with corporate convenience. The reality women lived through was not an abstract injustice that happened in a vacuum somewhere far away from you. It was a system, constructed policy by policy, upheld decision by decision, and dismantled only when the women it targeted demanded something better. Every protection that exists today traces directly back to someone who refused to accept the alternative, someone who filed paperwork when it would have been easier to walk away, someone who sat through depositions and cross-examinations while raising a child and wondering if any of it would make a difference. And the fact that new protections were still being written into federal law as recently as 2023 tells you plainly that the work is not done yet. If this story hit you the way it hit us, drop a like, leave a comment telling us what surprised you most, and subscribe so you do not miss the next one.